Okay. All right. It's July 2nd. Welcome Hammond North for a Board of Directors meeting. So the attendance for the directors are present: Jan Welch,
Yep.
present; Randy Vaughn,
Here.
Tracy Smiley,
Here.
and Chris Conti.
Here.
All right. Tom or Tim, I don't think you're on yet, right? Okay, so we have a quorum of 5 members, so we'll start the meeting. So the first item of agenda is Randy with the minutes.
Okay, yes, I move that we approve the minutes of June 13th, 2025, that board meeting. Those were sent out earlier, and I move that we approve those.
I second.
And Jan seconds. Any discussion? Let me add one point that I just was looking at them this afternoon, and there are a number of, I'll vote for it, but there are a number of minor edits which I'll make and I'll send to the whole board, but I think we can still approve the minutes. Nothing substantial. So no other comments? Okay, all those in favor of approving the minutes for June 13th? It's 5 members, which only have 5 members on the call. Okay, announcement of a unanimous consent motion. Randy?
Okay. Yeah, this is an announcement. On June 26th of this year, the following motion was made by me and approved unanimously online. And the motion was, I move that we authorize Ian Mitchell of the Reminger Law Firm to meet with attorney Robert Croskery for the purpose of exploring a resolution to that case, and if Ian deems it helpful, mediation of the Croskery lawsuit, and further, that a representative of the board be present at any negotiations. And that was approved unanimously by the board.
Thanks, Randy. Any discussion from the board on it? Any discussion from the members, the owners?
Well, and
Again, please.
I guess I should say there will be more clarification as to what all that meant a little bit later in this meeting.
Yeah, that's true. But if anybody wants to talk about that particular unanimous consent motion, but Randy's right. We have it as an item later to talk about the Porter and the Cross Street case. Okay, then I'd like to make an announcement that the distributed a we decided on a regular schedule for the board meetings, which the board decided to meet the 3rd Wednesday of every month, which will mean that we will meet again on July 16th, August 20th, and September 17th, and October 15th. Executive meetings would be 2 weeks before that. It'll be today, which we are meeting today after this meeting, August 6th, September 3rd, and October 1st. The meeting will be opened, a regular board meeting will be opened and then adjourned on these occasions per section 3.13 of the bylaws. So that's the regular meetings that I want to let everybody know about, so you can pencil that in for meetings. Any discussion from the board about that, regular meetings? Any discussion by owners on that? Okay. And it's not to say that there won't be some meetings when an important issue comes up, that we may have other meetings as we've done for the last 4 months. So the next item was an update on the reserve fund waiver vote. Jan, can you do that?
Yes, I'm texting people the link. Tim said he'll be on in a few minutes. He's moving today. Okay. So with the latest count, the consent to sell is at 118, and the waiver of the reserve funds, we just received 8 in the latest emptying of the box, which brings that total to 125. We only need about 135, I think, for that to pass. We usually like to have a bit of a cushion, so it looks like that's going to happen. We also have a subcommittee established that's going to work on the cell. And if there's any wrap up needed with the reserve fund, by then we'll be working on that. So the thought is that we can make phone calls and talk to people about what their concerns are and try to address those. So you'll be hearing more about those. A number of people have volunteered. I know a lot more people are interested, and it's we're going to have a core committee initially, and then it'll probably be expanded. So thank you everybody for your interest. And I think that's it. Any questions?
Okay. Hearing none, then we'll move on to the next item, which would be the litigation. I think that's Randy.
Yeah. So as most of you probably know, the Porter et al. Suit won in the appellate court, and that was remanded back to a lower court for a jury trial. In mid-July, there will be a hearing to set the calendar for the proceedings in that suit. Yeah. Okay. And then in the that's where that is. There has been no formal discussion or decisions about anything that the board will do in response to that as yet. The cross-creek suit is which you just heard a motion about. That suit and the Porter suit are both being the association is being represented in both of those by Ian Mitchell, who is an attorney with the Reminger law firm. That he is being paid, that law firm is being paid by CNA, who is our D&O insurance carrier. And so as far as the association is concerned, we have no legal expenses at this point involved with either of those lawsuits. Now, with Crossbury, we do have a countersuit that has been filed concerning HOA fees, and that is being represented. We are being represented there by the Finney law firm, which we do have to pay for that one. But at any rate, we as far as the Crossbury suit goes, we have not. We've approached them, as it said in the motion. We've allowed Ian to approach them to explore. Basically, is there any resolution that can be reached in this thing? But again, that is there's been no developments in that we know of. In our executive session tonight, we will be meeting with Ian, and maybe he'll have some news along those lines. If we hear anything, we'll certainly report that to everyone. I think that covers all of that, unless there's some questions anyone has.
Questions? I'll give it an extra minute. I would expect some questions, but maybe not.
There's not always a lot we can say on lawsuits.
That's the thing.
How do
It
these
says
cases-
cases. Okay, you got it, John.
How do these cases affect the sale of the building? Basically, they have to, in general, they should be resolved before the sale of the building. There's some talk, some people have suggested that they could be resolved after the sale, but that gets very complicated. I think the board's intentions is to try to resolve these cases before the building is sold. So, David.
I'm just wondering if Diane Porter would want to say anything to the group at large about what's going on.
Could you unmute Diana?
I would be
Randy?
glad to.
Feel free. Rick.
Well, I'm hoping that the board will meet tonight and have a chance to discuss, and will come to the conclusion that they have no interest whatsoever in appealing this case. Clearly, an appeal would go on for 6 months to a year and get us back to where we were. So, which is again, nothing resolved. So, we really, the case was overwhelmingly overturned. Nothing was left of the original case. And that means we can go forward and to a jury trial. We also can amend the amend our case before the jury trial in terms of us taking a look at issues that got us where we are now and could be adjudicated. So hopefully this board, since they're an appellee in this case, they're named, the association is named, and so the current board represents them, and so they have standing now in this case. I trust that they will understand that our case is a derivative case, that anything that comes from this will be distributed amongst all the owners because it goes to the association to be distributed. So I have personally no interest in this case, financial interest in this case. We did win the right to be reimbursed for our transcript, not for legal fees, but for the transcript. So, I mean, if you want to say yes, that was, a minor expense, but that was awarded from the court. Otherwise, we receive nothing. Anything we get in damages coming out of a jury trial would go to the HOA to be distributed amongst all of us. So I guess that's where I'm challenging the board to say, what is your financial interest in this? Isn't it to get as much possible money back for the HOA as you can, as you think is legally possible? So I trust. Thank you.
Thanks, Diana. Next person up is Carolyn.
Yeah, so I'm sorry. So just want to be clear about the Krosky case because I was named in it and we got a letter from the prior attorney stating that the association was going to have to indemnify the board because the insurance company, the DO and EO insurance company, was not going to cover the board for that claim.
That's the letter that I think all the board members got that said they would cover legal costs but not damages.
No, I don't think they were going to cover legal costs either. Maybe I misread it.
And that was from CNA.
Yes, that was from CNA or whatever our EO and DO policy was.
Yes, CNA. We can ask Ian Mitchell. He's a CNA sponsored attorney, Reminger, as Randy said, and we'll
Okay.
check on that. If you could just take a picture of the first page, I'll compare it to the letter that I have from CNA that I may or may not be the same letter, so I can confirm it. If it's not the same, I'll ask you to send the whole thing.
Okay, that's fine. I'll get it. I'll look it up and send it to you.
Thanks. Randy?
Yeah, but in reality, they may have said that they wouldn't cover attorney fees, but they are. They're the ones that hired Reminger to defend defend in this.
Okay, then that's good. I'll look at the letter. It's been it's been probably 3 or 4 months since I saw it, but for some reason I was understanding that they weren't covering the claim.
Who's representing who in the?
Okay. Can we unmute Michelle?
Yeah.
Thank you. I want to just make a quick comment about the legal cases against the association. I'm really disturbed that it's being sort of put out there that no harm, no foul. Let's just make a deal and get this over with. I just want to remind everybody on this call that every owner had their HOA fees increase 4.95% for the last almost 2 years to fight this legal case. We are out as a collective, hundreds of thousands of dollars. And we're being told that somehow we were being sued in order to give us back the money. This doesn't make any sense at all to me. There is a very quick solution to this issue now that we're all in this same awful boat. And the very quick solution is that the people suing the association drop their legal cases to the benefit of all owners and allow this community to come together, to not have to deal with any more legal cases, clear the path for the most expedient way of selling the building, either through direct sale or through partition. The idea that somehow we have to negotiate, and I'm sorry, this is my opinion, with people who I believe are holding our community hostage for additional funds right now. We are all out hundreds of thousands of dollars that we're never going to see again. My primary concern right now is to implore the people suing the association to simply drop the case and move on. Your
We cannot have
neighbors
this
are
argument
suffering.
on this
Right.
meeting. We can't have an
I
argument.
understand that, but I'm just asking them to please consider that for
Okay,
the
you said
betterment
it.
of all. So I'm done, and I appreciate the time and the chance to speak. Thank you.
Okay, thanks, Michelle. Anybody else? I know
Thanks,
it's a very
Michelle.
difficult question. All right, then we're gonna move the agenda, then, that's the port. Vicky, do you want to say something? Can we unmute Vicky?
Hi, thank you. I know Diana said that we would all, if they win their case, everything would be split amongst everyone. I know that when you have a case like this, the attorney who represents the winning side typically gets 40% or somewhere around that of the amount won in the case, unless it is specified beforehand that it is a certain amount. My question to Diana, which I put in the chat, is what is the arrangement with your attorney that if you win, how much would he get? Because that directly affects the amount of money each of us could get from your winning the lawsuit. I think everyone needs to know.
Diana can answer, but I'd prefer that we didn't have back and forth between the owners on the call.
It needs
So
to.
Diana, if you could make it short.
Obviously, nothing can happen for 30 days until it's decided if this will be appealed or not. That question is totally not in the sequence of what's going on right now.
Oh, you bitch.
To that.
All right, I'd like to call on Marion. I think you're.
That was
up.
really inappropriate. I
Yes.
heard some foul language, and I think at this point, John, we need to consider muting.
Yeah.
Can I speak now?
Yes.
Yeah, I also support what Michelle said. The conundrum is that Diana pointed out that if they win their appeal, the money comes to everybody, but the money is not coming from our insurance. They are only covering fees for the case. The money would come from the association, and then it would go back to it just is a weird kind of thing. We are still paying. That's the important thing. Our insurance will not pay any kind of award should that occur. Thank you.
We need to stop this debate now. This is not appropriate forum for arguing this case.
Okay, if there are any other hands up, anybody else wants to comment? I think then
I
if there
think we
aren't,
should move on. We should move on from talking about legal matters on here
Yeah.
because everyone has an opinion. And if one person can express theirs, then another person can. And I think, we don't want back and forth. I think it's inappropriate and we should just move on.
I agree.
okay, that's just what I was about to do. So the next item on the agenda I have is building insurance, which is for me. So we had the first 10 million of insurance. We signed that. The premium was about 548,000, which is about approximately 30,000 less than it was last year. Regretfully, the same insurance situation was last year and the year before, that the first 10 million of any insurance policy, or all our insurance policies, was the most expensive and was around $500,000. So we signed that with the agreement that Driehaus has said that we could do that. But I should add that the board is contemplating, not a firm decision yet, and would get legal advice to amend the bylaws to change what our mortgage requirements are. But at this point, that's what we've paid. And that check, I believe, Greg took care of, and Andreas has been paid. There still is the minor part of directors and officers insurance and liability that still have to be paid for. I don't have the exact amount, but directors and officers is about $6,400. It's a $2,000 increase from what we had before. I don't have information on liability, but we are covered now. And with the caveat that if for some reason we thought that we needed additional level of coverage, we could add coverage. But at this point, that's what we're doing. And it's a savings of approximately $400,000 from what it was last year. Any questions on insurance for the current year?
No questions, but I want to add to John what you just said. So even though this is savings right now, obviously we'll see if we need to get an additional amount or not. And at that point, we can attest to the insurance that we said we would use to actually pay for that. So it's a good thing that we don't have to further deplete the reserves because of insurance.
Any other questions? Comments? All right, we'll move on to the next item, which is the partition action and direct sale, which Jan, I think you gave the update. I didn't have partition numbers, we're still getting on that, but it is, I think, well over 75% of the building. So we have the numbers for direct sale, which we need 10 more, maybe a few more to margin of safety. But we have that, so we'll be able to save that money. On the partition action. Direct sale, as we all know, is 100%. So we have two updates. One is on a broker, Marcus and Millichamp, which the board members have met with a few times, and they've toured the building, and I turn that over to Randy.
Yeah, they are these are commercial real estate brokers, and they're very positive that they will be able to round up several offers for the building. They've prepared, they prepared a brochure for us, actually 5 brochures, very professional. It makes me want to move into the building. I kind of liked it, but anyway, they are reworking a couple of the brochures, and those brochures will actually then be presented to prospective buyers of the building. They think, they know, they're aware of our 9.8 million appraisal that we got several months ago on the building. They think that is a thing of the past. They are pretty sure that they can present the building in such a way that investors would be eager to invest, to pay more than that for the building. They're very astute. They've looked at when we get these brochures, by the way, we will get those out in an email attachment so that everybody can take a look. But they were very astute. They've presented the building in 3 or 4 different as 3 or 4 different possibilities of as what an investor could do with the building. They could rehab it, turn it into upscale condos and go that route. They've also done, they are very aware, they're based in Cincinnati, so they're very aware of what the current market is for condos, for apartments, and that kind of situation. So they could turn it into a condo again, upscale, or upscale apartments. They suggested that in the city there is a need for senior living, not the kind that offers a meal plan and all of that, but just a senior housing development. And they realized that this building would be excellent for that. You know, what with the elevators, you don't have to go up and down steps, that kind of thing. So, you know, they're very positive. They've got a real marketing plan to literally to sell the building. And so we will, as soon as we get that going, they hope to come in a few weeks with a couple of offers that we can look at and go from there. So to me, that's very exciting. Now, you know, there have been a lot of things all along here that to me have been very exciting, but they didn't happen. So, you know, we'll keep our fingers crossed, but this is definitely a positive a positive thing. And so we'll get you all that information and let you meet those people as soon as possible. And that's pretty much it for Marcus and Millichamp. And then
Yeah, I was going to take over.
okay,
Tim.
now do you want me to talk about this partition action thing, John?
I'm not sure what that is, but in a minute, let me just add with Marcus and Millichamp that they said there were a number of examples of their clients who got bids from potential buyers, even though they knew that the sale couldn't happen for another year. And that was very hopeful, given it's not the same as our situation, but it was very helpful on that one. So let me just let's pause and let's just see if there are any questions about about Marcus and Millichamp.
In the chat, let's see. Okay, yeah, in the chat, there's a question or basically a statement that, you know, the broker should get this going as quickly as possible. Question about do we all need to vote yes? All 880 owners have to vote yes to sell the building directly, and that is yes. We would, and
So that's going on at the same time, the partitioning action, right? I think
right, that vote is out. That's the one you reported on. You said, well, we have 118 so far out of the 180, 118 units have done that. What else? Is there a separate land appraisal?
I'm pretty sure there isn't. It actually technically ran into this in terms of title search. There are two pieces of property. One is the footprint of the building and the garage, and I think the parking lot, and the other one is really the meadows and the woods. And they have separate titles, but the sale would be of both.
And then there's the question, I don't know if we want to address this right now, question of can we change, could we change the declaration if we get 75% of the owners to vote to change the declaration? Could we change the declaration to say that we only need 75% of owners to approve a direct sale? We've talked about that with our attorney. There are definitely pros and cons, and I'm honestly, I don't have my notes with me, so I probably would do better just to leave that alone for right now.
Yeah, I mean, I think Isaac was pretty clear that he had said that you really, at this point in the process, having already had 75% saying do not sell, having 75% for petition that to change the bylaws at this point, probably creates other legal problems.
And then another question, are electronic signatures acceptable for an agreement to direct sale?
I I think they are. We don't have the direct sale with a DocuSign document. We asked Isaac to do that, and I'll follow up with that.
If anyone needs that and we don't have it, please call the office. We'll figure it out somehow.
Yeah, the forms are online, so you can download them, you can sign them, take a picture of that, and send it to Greg, and I believe that will be acceptable. But if not, we'll make sure to get the DocuSign going.
I was gonna say, John, I thought Brandy, she didn't set that up for this vote as well as.
No, it's not, hasn't been set up yet. I did talk to Isaac about it. I'll follow up with that.
Mhm.
Okay, I think
Okay, you
I've
had
hit
some
all the
comment
chat
about
questions, I believe.
partitions, Randy?
Okay. Yeah, you're going to receive a one call tomorrow, everybody. And it needs your attention. We've all got some homework to do here. In the petition action, as well as in the direct sale, if we go that route, our lawyers need up-to-date ownership information. There's a lot of fluctuation they've done title searches. There's a lot of fluctuation in who owns each unit. A lot of them are straightforward and very clear, and that's fine. But there are some where there is maybe an executor, there's maybe an LLC involved, maybe an heir if someone has passed away. Lots of changes. Matter of fact, just this week, I think we had to relate to our lawyers 3 changes, I believe, off the top of my head. So they have got a document that we will be sending out tomorrow by one call. All the units will be listed, and the information that we have, the legal information we have as concerning who owns each unit will be on that. What we would like you to do is it'll be an attachment, but we would like you to look at that attachment, look at your unit, and see if that information is correct. This is the best information we have at this point. The reason we're going to this is I got this list, we got this list a week ago. I went over it. I found several errors in it that I knew about. You know, I knew of a person that had passed away who was still listed as the owner and that kind of thing. So the easiest way for us to do this is to have each person, all 180 of us, look at that document and see if the information for your particular unit, or if you own more than one units, is correct. Whether it is correct or wrong, we would like you, there are going to be 3 email addresses at the bottom of this one call. And we would like you to please pick any one of the 3 addresses and respond, either telling us, yes, the information for unit XXX is correct, or the information for my unit is incorrect. Here is the correct information. Okay. And obviously, the faster we can do this, the faster the partition action can be filed. It's ready to go as it sits, but this is one last proofreading just to make sure we have it right. Reason for that, if it is filed with incorrect information, and then we later on find out, oh, this is the right information, we have to file an amended motion. And of course, that's more lawyer fees, and that's also more wasted time because then all of the defendants in the partition action need to be notified that there was an amendment made. So that's more mailings. So if we can get this as right as we possibly can before we finally submit this to the court, the better off we are. So look for that one call tomorrow and check your information and any one of the three emails listed at the bottom, it's mine, John's, and Chris Conti's, any one of those three, just respond to it and let us know, is it right or what is wrong with it? Okay? So
Yeah.
thank you in advance for doing that.
There was one question which I was going to raise also, which is, can you see everybody else's information? And the answer is yes. And there was a concern that the board had about doing that. However, it's a public document. It's going to be listed on the website. And therefore, going through the hoops of trying to separate that out, the document didn't seem to be worth it. We hope people would treat that information appropriately, but it is going to list everybody else's information. Another
And-
thing, yeah, go ahead, Randy.
I was just going to say, yeah, and we did go back over that, and it is purely ownership information. There's nothing about lawsuits, nothing about a mortgage, nothing about child support or any other kind of lien that may be against the unit. It is purely just who owns it, and the percent of interest, a percent of ownership that that particular unit has. So there's really no, I don't believe there's really any sensitive information in it. At least that's what we hope.
Yeah, there was a question about, is it the same as the information that was asked by the Finney law firm, Randy Fitch, the paralegal? And it's probably very similar, but I believe the question was on part of what is written for your unit, but it's not all the information. And everything but as Randy said, that's the main information, the ownership. Let me also say, for those of you that signed with power of attorneys, we've been contacting you. We got to be sure Finney law firm has the copy of the power of attorney for any of these units. Any questions about this request? I know that one question was, the marriage question, and I think those emails went out already, a mass email, and I don't think any of those questions are going to come out again. All right, if there are no questions on the aspect of petition, then the next up is the other potential buyer is Mike Stacy, who is an owner of 2 units in the building. And there have been numerous meetings we've had with Mr. Stacy, with board members about this. We've gone through a couple of drafts of his proposal with Art Goldberg, and he submitted that letter to Art, and along with portfolios that the board had asked, and we got those information for his information on his companies, which is Ram Restorations, Airway Construction, and 10th Street Ventures are the main 3 companies. And we wanted that information to look at that before we pass that forward to Art Goldberg. Art Goldberg's going to look at it, see what he wants. It's a complicated plan without getting into a lot of details. The plan involves whether he can do some work before purchasing the building, and the board and legal counsel will have to figure that out. But at this point, it's way before a purchase, and the purchase still has to go down the route of either direct sale or petition action, which can be under petition action. It could be a sale to an owner, or it can be again to a broker, or a direct sale at that point. So,
Well, and I'll add to that, and that's between Mike Stacy and the city, right? So we have no bearing of that communication, since we're not at a point to actually sell the building. Once we get to that point, then that's something we could potentially entertain then. But this is just, information that's being shared back with us. We're not involved.
well, actually, what we wrote to Mr. Stacy in an email, and I think the written agreement that we had with him, was that he would keep the board informed of all communications. That would be involved in phone calls, would be CC'd on emails. And I think that it's prudent for our responsibility as the board to know what is being said and to know what's going on. Mike is familiar with the building. He's worked on the building over the years, but it's a complicated situation as to what has happened over the last year and a half, what the situation is in the building, what has to be done. And so anyway, there are different opinions as to how much we should be involved, but at this point, we still are. Any questions? Anything on the chat?
Don't believe so.
Okay, I do have a proposal then for bills. So for that, Tim's not on. So Randy, as secretary, can you take over the chair? And I will propose 2 bills.
Okay, Chair recognizes John for the purpose of a motion.
All right. Last Thursday, we approved partial payment on 2 TRS bills. And we had phone calls with them today. And basically, we came to a compromise solution for the equipment, the scrubber fans that are still in the building, for the exhaust, for basically it's a bypass ventilation. They had previously removed the scrubbers in the hallway, and those have been removed. We've also asked for the scrubbers in the bypass ventilation and the 9 stack be removed, because once the last unit had left, then there was no purpose for ventilation that we saw for that unit. But we found there was a agreement between the insurance company and TRS for a set amount every month for the equipment. So originally it was $37,000 a month. The compromises we're going to pay, I'm going to propose $35,000 a month. On top of that 35,000, there's $2,730 for a total of 37,730, which before was about 80,850.
Yeah.
So Jan, I think I should make the motion and then we'll move on.
Before you make,
Okay.
Before
Did
you
you
make
make
the
a-
motion,
Okay, so I was just, sorry, that was background. So for invoice number 2945, I'm proposing to pay $37,730 for equipment costs.
Is there a second?
before we vote, John, do you have copies of those invoices?
I think we should have a second first before we
Yeah,
discuss
is there a
it.
second and then we'll discuss?
Okay, sorry.
Jan seconds. Okay, discussion? Tracy?
No, I was just gonna ask if we have copies because I haven't seen anything come through.
Okay,
say
we
that we
don't have
paid
a
you.
we don't have a separate invoice for this. It was part of, it was equipment, was listed in invoice 2945. What we did last Thursday, we approved $80,850, which was the non-equipment part of that bill. And we did not pay the $80,850. I'm proposing that it's a partial payment of what's remaining, and there's an agreement with TRS that will resolve that bill.
So John, this is not the items we discussed with them today?
Yes, it is. This is bill number, I believe, month 29 is from April 16th to May 13th.
Okay, so it was originally $75,000 a month.
Plus tax, yes.
Right.
So it's now 35,000 plus tax.
And this is a potential agreement pending board approval. And
Yes.
and it was not, I made it plenty clear that we are, if we pay this bill, we are not paying it happily, and outlined for them a lot of what I sense as the opinion of owners in terms of the way they went through this building, and how unwanted they were basically in the building at this point. And tried to explain some of our bad feelings about the whole situation. And we've also talked to Isaac, right? I was not involved in those conversations, but he feels that we should dispose of this and not let it continue to hang over our heads and take a lot of our time. Am I right about that, Randy or John?
I think so.
So that's kind of why we ended up where we are for the last 3 months. And so.
Hey, any other discussion from the board or questions?
Got a question. As I understand, this was 75,000 and it was negotiated down to approximately half of that. Is that correct, John?
That's correct.
Okay.
A little less than half. Or is it exactly half?
It's a little bit less than half.
Yeah.
Okay, any other questions from the board or comments? Okay, seeing none. We
Wait,
do have a couple of check.
sorry,
Yeah,
sorry.
Tracy.
I did, so the previous invoice we paid, the previous invoice is 131, but we only paid about 50,000. So this is the remaining 80,850.
That's correct. I misspoke about the 80,000. That's what we subtracted. Correct. We paid 50,569.
Okay, so in total, we're paying the 131,419, which was the
No, we're
original.
not. Minus 37,730.
Okay, so the invoice you have for the 80,850 is minus 37.
Actually, I take it back. We'll have to do it. We're paying 37,730. And I have to
Okay,
have another math for that. We can talk later about what is remaining that will not be paid.
okay,
And-
so we're paying 37,730.
Yes.
Okay,
And we're saving about over the 3 months. How much, Randy, did you calculate that to be earlier? It's
Well, about 120,000, I believe.
Yeah. It's not like a great
Okay,
saving.
and we're sorry for all the confusion on this. This just occurred this morning, so we haven't really had time to sit down and hash out all the issues
Okay.
involved. And okay, any other questions from the board or comments?
Well, one other thing, it is contingent upon timely payment of the remainder of our bills with them.
Is that correct, John?
Say that again.
yes.
It's timely, it's contingent upon timely paying of the bills.
Yes, I mean, they also said they don't want to have a problem with the hoist, which should be coming down starting July 7th over the next 5 days. And that bill will cost 17,000 from American Scaffolding, as well as about $2,000 for the electrician dismantling the controls on that.
And
So
then, and the final bill, which is month 31, is not included in the current.
that's correct. There'll be another, I'm not sure what the bill will look like. I hope it will reflect just this amount and not the 75,000, which will make it neater and cleaner that we pay the entire invoice, but we'll see what TRS sends us.
But there are still separate from that category. There are still some staff working administratively, I think mostly, right?
Yeah, I mean, that's a personnel charge. That's a separate part of that bill. That's been going down significantly, but it's still there. And for instance, I know there was bills when they operated the hoist had 3 people a day, which are required by the codes, but they had it for every day, even I think through May, and that cut down to once a week. And we also have asked both Hunt and TRS to give us a description of what the job is that people are doing on the project at this point in time, which clearly is winding down.
Any other comments from the board? Okay, there's a couple of chat questions. I'm going to split this one in half. I think we'll talk about the other part of this question in a little bit. But anyway, where is the contract for this amount? Did the board approve said contract?
I guess I'll answer that. There was not a contract. There was an email record for it. There is discussion. What we've heard is that previous board members were involved in that discussion. Previous board members have said there was no discussion on this particular contract, that it was between TRS and the adjusters for Landmark. We went back and forth on that, and I would defer more to what Janet said, that Ian had said, sorry, that Isaac had said, that basically it becomes a he said, she said situation, and it's going to be difficult to win this totally. I'm not happy with this settlement. On the other hand, I think it's probably the best that we can do at this point without dragging this out into a more lengthy process that costs us all legal costs, and I just don't think it's worth it. So that's why I made the proposal.
And the other thing is that Katrina is fond of saying, you know, if you don't pay this, we'll go back to our original contract, which will cost you a lot more.
Which the lot more basically is the amount I find myself in strange agreement with Landmark that the charges that TRS was charging per fan that they owned and was not rented in the last couple of months, to be a very high amount. So just because this agreement did bring this amount down, that's true. But the previous amount, I think, was highly excessive.
Another question, doesn't the Ohio Consumer Protection Act protect us against, quote, unnecessary services? I might be able to handle it. It does probably. I don't know. I don't know the act exactly. But it does sound like once you get the government involved, it's going to be a lot of time and a lot of perhaps legal expense, but I don't know much about that. Anybody else? No comment. All right. Will we be reimbursed for all the equipment and supplies that we purchased and left unused?
That has not been raised.
Okay. And all right. Why are we agreeing to pay this bill if they had no right to ask that of the insurance company?
Well, they already have an agreement with the insurance company for this. I'm not happy with that agreement. I don't believe we have asked repeatedly if there's any evidence that the board approved this agreement. We couldn't find that, but we have descriptions that board members were involved, and it is basically something that is going to be an argument back and forth. And we don't see taking this to court. And we don't see dragging the lawyers into it also, as busy they are with everything else that we're doing. It's not a great compromise. It's a compromise both ways. TRS, I should say, offered a compromise a month ago, which I thought was excessive amounts, and we got them down substantially from that amount. Anyway, that's the best I can say on that.
Yeah, there are a lot of tough questions here. Didn't the former board pass a resolution that TRS could not directly send bills to the insurance company without being presented to the board first?
It's clear to me that TRS and Hunt have a lot of direct communication with Landmark, with Jason's approval, to answer questions that Landmark is raising. I don't believe they sent the bills directly. We get an insurance payment. There's some comments on it as what they are reimbursing us for, what damages or remediation or rebuild they're doing, but it's not payment for a bill. But when we get the payment, then Hunt and TRS are well aware that it gets sent. There is communication with all of us on the Wednesday morning rebuild meetings, construction meetings. So they're aware of it, but I don't believe the actual bill. I've heard that from both sides, but from Jason, TRS, is that the actual bill does not go to Landmark.
Okay. Were the new hall carpets ever ordered?
No, and that was one of the first items that we were dealing with in the very beginning. And we looked around in February and thought that we should do it. The deal was to buy the carpet because it was by unit foot. It would be cheaper to buy the carpet for the whole building and leave it in a warehouse to be installed floor by floor. And we decided we were not going to make that purchase. So it was not ordered. On the other hand, there are other stuff that was ordered that was in the pipeline before this current board was elected. And so there are on the first floor, this is not the question, but on the first floor, there is ductwork for all the floors. And there's also HVAC coil units for all the floors up until I think 16, I think 17, 18, 19, those new coils have already been installed.
Okay. And I'll just wrap it up with this question and then we'll go to a vote. When are we done with TRS and Hunt?
I don't know.
Yeah. No. Okay. There's some other chat questions. The one I'm looking at are kind of off of, well, I don't know if this has to do with anything. How many residents are still in the building? But anyway.
I think it's
I know.
16 now, 16, 17. right now, and I think almost everybody has a date to move out by, I believe, August 2nd. There may be two that have not had a date. There's one unit where they're renovating the new unit that has to be done, and it's not clear when the date will be done. And I think maybe two others that don't have a firm date yet.
Okay. So if there's no further discussion on the motion, which was to pay the invoice in the amount to TRS in the amount of 37,730. I will go ahead and call that and ask for a vote. All those in favor of paying that invoice, please raise your hand. Oh, okay. Passes unanimously 6-0 with all present. And I will turn that back over to.
Wait, not so fast.
Oh, I won't
I
turn
have
it back
another
over.
one. That was Bill 29. There's Bill 30, and it's basically identical. Hopefully, there won't be too many questions. This is
Oh.
invoice number 2969. That is for a total of 102,363. We paid $21,513. It's for the period May 14th to June 10th. And I am proposing the same terms that we pay $37,730, $35,000 for the fans, and the tax of $2,730 for that total of $37,730. And I so move.
Is there a second? Chris, okay. Any discussion on this one? Okay.
I didn't have, I had the original bill of 102,000. Do you have the invoice you can send me, John? That was 21,513.
We don't have an invoice. I just have my notes that on that bill that we approved that amount of money. And it should be in the minutes that Randy sent around.
Okay, when you get the invoices, if you can send both of those, that'd be great. So I can
Okay,
mark it as paid.
I don't think we're gonna get a separate invoice for it. It all falls under the payments of 2969.
Because it was negotiated.
Right. We can talk later, Tracy.
Okay, as long as they revise it and send another one so we can keep a copy just to cover ourselves, that'd be great.
Okay.
Okay, all in favor of paying invoice 2969 for $37,730 to TRS, please raise your hand. Okay, passes 6-0. Is that all, John?
That's it. And then the only new business I have is, do we want to have a discussion, or does anybody have any motion about a final date? I think we've mentioned before, we need to move up the date that possessions will be out of the building, which right now I think is December 31st, as well as appliances and other items on the upper floors. Andy.
And just in keeping with Robert's rules, which we sometimes do, I'll make a motion, and we can amend it or whatever you want to do to it. But I move that we set September 30th as the deadline to remove all personal items from the Hammond North building.
Second.
Is there a second?
Second.
Tom seconds it. Discussion. Jan.
I would like to table this for the time being. There's just a lot going on, and a lot of people have a lot of things to get to figure out in order to get things out of the building. And I think in a month or so, once the building is empty of people and occupants, we'll be better able to figure that out.
I will second the motion to table.
Well,
So
that was
do
the
I. I
questions.
think, yeah, I think once we figure out staffing of getting owners in and out of their units, and we figure out how many are going to request to get in and out of their units, and actually build a schedule for that, that will help us figure out what the timetable is. And I'm not sure what drove the need to move it up, but if we can table it and discuss it later, that'd be great.
All right, so I think motion to table takes precedence. So all those in favor of a motion to table? All right, Okay, all those opposed? Abstentions, Randy, that's
Abstain.
opposed, right?
We got it. Yeah, 4-1-1.
And Tom, you're opposing or abstaining?
Abstain.
Okay. All right, that's the last item I have. Are there any other motions anybody wants to propose? All right, and seeing none, we'll adjourn to executive session. Thank you very much.